we were just discussing one of the benefits that you might have if you do the case in Pearsall is that you can hitch a ride with us when we go down to Pearsall, and Stephanie and I are super fun. So, we get a rental car, and we get up really early in the morning, and we just drive, and we have the most interesting conversations. Stop for breakfast tacos, craziness. Okay, so we're going to talk a little bit about preparing the case and preparing and amending the immigration, the application, which is the I-589. It's just the asylum withholding or convention against torture application. Preparing for your interview for asylum if it's affirmative or for court hearings. And then when I'm done with this part, you'll hear from some sort of mock materials, sort of a mock cross-examination I think you're going to do, and some more concrete information about how to represent somebody in court, and then you'll hear from the judge. So we have a little bit of information here about ineffective assistance of counsel. Basically, if you have a case where prior counsel was ineffective, it may be possible to move to reopen a case due to ineffective assistance of counsel. The requirements for making out a case of ineffective assistance in immigration court are fairly rigorous. You have to provide an affidavit describing the agreement with counsel. You have to inform the counsel of any allegations against them and afford them an opportunity to respond. So you're going to have to be in direct communication with the other prior allegedly ineffective counsel. And then you have to report whether a complaint of ethical or legal violations has been filed with the proper authorities. And if not, why not? So basically, you need to make a bar complaint. And if not, there has to be a compelling reason why not to. I've had to do this once. It's pretty miserable, but it was effective. So, and in the Fifth Circuit, the representation by prior counsel must be so deficient as to impinge on the fundamental fairness of the hearing. So if they, it really has to be fairly ineffective for this to work, unfortunately. So, kind of a mediocre attorney might not rise to the level of ineffective assistance. So when you prepare for your case, first of all, you want to research country conditions before meeting with your client, because nothing makes you feel dumber than if you don't know who the president of their country is or something like that. So, look through some maybe New York Times articles and read the State Department report on country conditions and see if Human Rights Watch has anything, or asylumlaw.org, or some of the resources that Natalie will probably familiarize you with. But learn a little bit about their country. And then it's very important in defensive cases to review whatever forms are already in the case file. So, for example, the I-213 is the record of deportable inadmissible alien. That is the record that is drawn up by the person the DHS officer who apprehends your client. And it's a question and answer format, and quite often they'll talk in some detail about their asylum claim. And you want to make sure if there are any inconsistencies between that and what they're telling you, or what's going to go in their affidavit or their declaration. You want to be really clear about why those inconsistencies are there. One thing to be really alert to is language problems, because sometimes those records of deportable aliens are sometimes it's very obvious that there was lousy translation. So you want to figure out if that was the issue, and you can ask, was there an interpreter there, particularly if somebody has an unusual language other than Spanish, basically. And the credible fear determination worksheet is also very important. If someone comes into the United States and says they have a credible fear or a fear of return, and let's say they've already been removed in the past, they're going to do a credible fear interview, a reasonable fear interview. And basically, this is a preliminary interview that will determine whether or not the case should go on to a judge in immigration court. So you want to review that record very carefully. Again, there may be some issues with the interpreting. There may be issues, if you have a client, let's say, who's one of these matter of RA cases, a domestic violence case, and there's been like sexual violence against them, they might not include that information because they're probably not going to want to tell that to like some border patrol agent or you know, even the asylum officer, you know, whichever officer is conducting the credible fear determination. So they may omit information for very good reasons. You don't necessarily have to assume that if their story is more detailed later on, that it's false. And then you want to review the notice to appear, and that's the charging document in immigration court. Make sure, you know, it's all correct, such as, you know, their name, the country they're from, when and approximately where they were apprehended, or when approximately where they entered the United States, and review these forms. These are all forms that are probably going to come to light. Well, definitely notice to appear, obviously, but the I-213 is quite often introduced by the government for impeachment purposes if they think your client is not being straightforward. So when you interview your client, you want to obviously have somebody who is very proficient, fluent in that language. Either yourself, if you speak Spanish, that's great, and your client is from a Spanish-speaking country. Otherwise, we do have volunteer interpreters, and we have a volunteer coordinator that holds who can help you try to find somebody. And you sometimes have to be kind of scrappy about this. Unless you work for a big firm that wants to donate, you know, the services of an interpreter, and you know that's great too. But or pay for the services of an interpreter. But quite often, if you know call the University of Texas, recently I called the Middle Eastern Studies Department and got a Dari interpreter who went with me to Pearsall to interview somebody kind of low bono for very low fee, but or you know sometimes you can find volunteers. Graduate students are really great for this, things like that. Pay attention to gender dynamics. You know sometimes you know the best attorney would be somebody of the same gender as the applicant, but that can't always be the case. But just realize that if somebody's been traumatized, they're not going to necessarily. You don't want the first question that you ask them to be very invasive. You want to start off and establish trust. You want to always explain to your client. One of the first things you want to say to them is that everything that you discuss is confidential. They may not be aware of that. And that you don't work for the government, that you're there as their advocate and you want to try to help them. And you know, just explain kind of the framework, because they don't necessarily have the same kind of legal system as we do. It may take a few meetings. You know, filling out the asylum application, it's a really long application. It starts with very detailed biographical information. So express an interest in, you know, where they went to school and what they studied and where they grew up and what languages do they speak there, and really just develop a rapport. I know quite often lawyers are kind of brusque, and you want to at least pretend to not be. Well, I mean, you know, sometimes you're in a situation where you have to get the information really quickly, but just to the extent you can, establish a rapport. So, if the form has already been filed in the court, well, sometimes the judges will give the form to somebody who pro se expresses a fear, so you may bring with you, if you're going into detention or if you're meeting with a client in our office or your office, bring a form I-589 so you can go through that. There's no filing fee. And on that form, you know, there are detailed questions that you want to be really skillful in interviewing somebody. For example, you know, have you or anyone in your family ever, you know, I'm trying to see, been a member of any organizations or groups or anything like that? You know, you want to find out if their dad was in the army in Honduras in the 80s. You want to put that down because that's a family member, and really find out in detail. I always put churches, things like that, any kind of organization that you know is not a governmental organization, but the person is a member of, may be relevant. In an affirmative case, you file it with the Houston Asylum Office, it gets filed with the Houston Asylum Office. In the defensive case, the U.S. Immigration Court. Always look on uscis.gov to find the exact address of the office where you need to file any application. That goes for asylum and other applications. And the Immigration Court EOIR, if you Google it, I think it's eoir.gov, has a website with a virtual law library, and it'll have all the addresses where you need to file things and all the forms that you need. If it's a defensive case in immigration court, you're also going to need to file an E28. EOIR 28 is a notice of entry of appearance of attorney. So the I-589, if it's already been filed in court, you are going to check it and see if it seems adequate. In most cases, it probably won't be, and you're probably going to want to do a motion to amend and file a fresh I-589 if possible. And let's see, affirmative cases, you can file documents up to and including the day of the interview. That's not so in immigration court. There's a 15-day calendar days deadline before the merits hearing. You actually start counting on 0 on the day of the hearing, so it's more like 16. But you want to look at there's a manual that goes for basically all immigration courts in the United States, the Immigration Court Practice Manual. And really peruse that, because there's really specific information there about where to put tabs, about how to do cover pages and all that information. So your client affidavit or declaration is a very, very important document, and you want to be really deliberate about what information you put in there. If you put in a specific date, that better be right, because you don't want to put in a date that your client maybe your client thinks you're asking them what date something happened and you want an answer, and they're just going to make up an answer. And if you put that date in, they're going to be held to that, and that can be used against them in the credibility determination. So if your client is vague on a date, but they can pin down like a season or a year or something like that, you want to get as specific as possible while still being accurate. Sometimes the declaration might not have very many dates in it. Maybe they don't remember. It should be in a narrative style. Balance the client's voice with ease for the reader, and it should be a fairly detailed document. You don't want to put in so much detail that you're putting in unnecessary detail or putting in detail that the client's unsure of. So generally it's chronological. So when you prepare your client for court, you want to basically, if you have the time, which hopefully you will if you're a pro bono attorney taking this on, you want to basically do a mock hearing for them, and you want to prepare them for questions both from yourself on direct, also from trial counsel. Try to think of the meanest, toughest questions you can think of and pretend you're the trial attorney. We'll do that in our office with a couple of us. Stephanie will be the bad guy, or the DHS attorney. And then you also want to prepare, because the judge will also ask some questions quite often to kind of fill out any gaps in whatever testimony that didn't come out on direct or cross-examination. The client must maintain the same demeanor on cross and direct and when responding to the judge. So in other words, sometimes you want to warn the person that sometimes the questions that the trial attorney for DHS might ask might be inflammatory or perceived as offensive, and they should just go right ahead and listen to the question, and unless you object, they're going to have to go ahead and answer it. You also want to tell your client to look the judge in the eye. In a lot of cultures, it's polite to avert your eyes when you're talking to somebody who's in a position of power. When you're asking them questions on direct exam, they're answering to the judge. If translations aren't clear, the client should say something. They also, in the best case scenario, if you have a translator with whom you have a relationship that's maybe been helping you with your case, have them attend the hearing, because if the translation is defective, they can help you object. So in affirmative cases, and it's an asylum officer who conducts the interview, and it's a non-adversarial process. The attorney role is limited. You bring a G28, which is the entry of appearance as attorney before the agency, before DHS. and you may present a written or oral closing statement, but basically you're there to ensure the interview goes smoothly, to see if anything irregular happens, and to intervene in that possibility, but many times you're just there to essentially observe. In defensive cases, you may have to, as a preliminary matter in your case, make a motion for a bond hearing and present an argument in a bond hearing to the immigration judge. Yeah.
Do you set a bond hearing at your master calendar hearing?
They're actually technically separate hearings. So if you go to a master calendar hearing and you haven't already requested a bond hearing, but you're prepared to go forward, you may ask the judge if the judge would be willing to also do a bond hearing. If the judge has time, they may or may not allow you to do that. But basically, they are separate proceedings. The bond hearings are actually not on the record, but the master calendar hearing is. And so, usually it comes down to how busy the judge is that day. But you want to try to, do it the proper way, which is to put in a bond packet, to file that in advance, and then usually about 3 business days later, you'll have a bond hearing pending. And sometimes the clerk will actually call you and offer you a date and see if it's possible. So if the person, and I won't go too much in detail on bond hearings, but basically if the person has a good asylum case, they're likely to get a lower bond. So you want to talk a little bit about the type of asylum case you'll be presenting. And then also the 2 basic inquiries in a bond hearing are whether or not the person is a danger to the community, and whether or not the person is likely to appear in future hearings on the outside. Here in San Antonio, the immigration court address is there, and it's in your handout. Those are the filing hours. The court, EOIR maintains a pretty good automated system, so if you call that 800 number and then you put in the person's alien number, that's a 9-digit number that starts with the letter A. Everybody in immigration proceedings has one. It'll tell you when the next date of the hearing is. Actually, sometimes with asylum hearings, it won't give you that information, but if you're the attorney of record, you can call the court. Another thing that's really important to do when you first get a case is to go, if it's in San Antonio, is to go and look at the record of proceeding. You can also make a written request to get a copy of the recording of any prior hearings, and you want to listen to those. And of course, if the person has filed an application for asylum pro se and they don't have a copy of it, you can, once you're the attorney of record, you can get a copy of that prior asylum application. That's often how you're going to obtain it. People don't keep copies of things, often. So when you prepare somebody for the court hearings, you want to review any documents submitted by the government. And again, that's another reason to go and review what's called the record of proceeding, the ROP, in immigration court, because anything that's been handed into the judge will be there. If you want to get a copy of the person's A file, which is the file the agency maintains, you may not be able to get that as easily, but you can definitely review a file, put in a written request with the court. It's good to, if you're just going down to review the file, it's good to file the request a day before so that you know it'll be ready for you to review. Prepare any visual aids, prepare any, I don't ever use visual aids, I should. One of the things I often attach in an asylum application in the documents is a map of the country. So if that's helpful. I guess it's sort of a visual aid. And then phonetic sheet of pronunciations for frequently used names and places. So at a master calendar hearing, if you want to look like you know what you're doing, you want to know the last 3 digits of the person's A number. And then the judge will say, good morning, counsel, and you say, what case are you here for? And you'll say 321 or whatever it is. The first document that you hand in to the judge and you give a copy to the government, of course, is the E-28, unless you've already filed that in advance. And the proceedings are on the record. If it's your first appearance, quite often the judge will ask you if you want more time for attorney preparation. If you've already reviewed the file and advised your client of their rights, then you can go ahead and admit any allegations or deny them, and then concede removability or deny any charges of removability. So you're going to go over in detail all the the allegations and the charges on the notice to appear. And then you specify the relief sought. Don't designate a country for removal. If you're applying for asylum, you can decline to designate. And if it's the hearing where you're handing in your application, the judge will often ask if you need an interpreter for your final hearing. And for most individual hearings, you get an interpreter in person. The court does provide the interpreter for the final hearing. Sometimes there's a forensic examination of evidence, so if you've handed in a document that the government is alleging is false or fake somehow, they may conduct a forensic examination. They have an office to do that. The clock is a big issue. The asylum clock basically governs when a person may apply for a work card. A person who's applying for asylum may get an employment authorization document after 150 days after, well, they may apply for an employment authorization document 150 days after the application is filed. However, if the respondent, your client, asks for a continuance or delays the case in any way, the clock is generally stopped. The clock is set by the court, and it depends on the adjournment code. And so you want to be careful of that. So, for example, if you're going to, if you've already reviewed all the pleadings and you're ready to go forward with the pleadings, it's a good idea to do that as long as you're prepared, because if you ask for a continuance, it's going to stop the clock, and your client will probably, many clients are really savvy about this, and they're not going to like it if you stop the clock, because that means that they're probably not going to end up being able to work during the time that their case is pending. And particularly now, since non-detained cases are being set out to 2013 quite often, they're going to have to figure out how to survive that long without a work card, which is a real issue. The judge will usually ask if they've had a change of address. There's a particular court form you can also find on the UIR website for a change of address. And the I-213 is filed with the NTA. That's the record, again, that you're going to want to go over in detail with your client. If the client is detained, the government will take care of getting their fingerprints done. A background check is run, fingerprint-supported background check is run on every applicant for asylum or withholding. If the person has been released, you basically, it may be that they already did the fingerprints while they were detained, or if they were detained, and if not, you'll need to get a biometrics appointment. And there's basically a procedure for that. You send that to a particular address that the mentor will tell you about. So the evidence that you present, we've touched on this a little bit, the application and the affidavit or declaration of your client, country conditions reports, State Department report, other documents, any corroborating information such as police reports from the home country or photographs or maybe sworn affidavits of people who are still in the country that can attest to what happened to your client or what your client may fear. A good resource is asylumlaw.org. There's a good compilation of country conditions documents sorted by country on that website. And just be aware of the deadline. It's 15 days before the hearing. Credibility is everything in an asylum claim, particularly where you don't have a lot of evidence. So you want to make sure your client is aware of the dates and times and the number of events and things like that. Sometimes when somebody has been traumatized, they're not always great at remembering such things. And one thing to tell your client when you're preparing them for their hearing is, even if they don't know a date, that's okay, don't make it up. If they don't know the answer to a question or they don't know a date, say, I don't know, and stand your ground, even if the government attorney is like, well, give me a ballpark or whatever. Like, really, if they have no idea, that's okay, especially if they were children at the time that persecution occurred. So there are fact witnesses that you can have, experts, medical, psychological, and similarly situated persons. So if your client has any scars from past persecution, if at all possible, you want to get an affidavit from a medical doctor, essentially cataloging all the scars on their body, including ones that happened when they fell off their bike when they were 5, because that bolsters their credibility if they have, some scars that they concede really had nothing to do with the persecution. Also, I think the judge would agree with me that she does not want to see somebody lift up their shirt and show their scars, or like sort of get undressed and show scars. It's not really very useful. You want an expert to attest to the scars and sort of the origin of those scars. Telephonic testimony is quite often fine for experts. So you want to make a motion for telephonic testimony prior, 15 days, at least 15 days prior to the final hearing. You also want to include a witness list. So basically the trial often lasts 3 to 4 hours. It's not usually continued unless you have a very complicated case, or maybe you have a case that is maybe a whole family and you have a bunch of witnesses. The judge quite often gives an oral decision. And you should always contact the trial attorney prior to the hearing, to find out which trial attorney you have. So you can ask your mentor how that trial attorney generally questions people or what they seem to care about. And also to see if there's anything that you guys can agree on. So if you can agree, okay, well, there's no one-year bar issue here, there's no particularly serious crime issue. Maybe the trial attorney will clue you into what they're thinking, like, well, I don't think there's any nexus in this case. Then you know what to focus on as you prepare. So I'm running out of time, but basically some of this is a little repetitive. The trial begins with a master calendar hearing, and that's basically a status check with the judge. That's basically a preliminary hearing. That's when you take pleadings, and then they'll have one more master calendar hearing to hand in the asylum application. It may be possible to hand that in on your initial master calendar if you're ready. Opening statements are not particularly common in immigration court, but if you do want to make one, you want to keep it concise and get to just the facts about your nexus, which testimony, what your witnesses are going to say and why it supports your case, and perhaps if you have medical corroboration. Direct examination, credibility is really key. One of the main things when you're preparing your client, don't ask them the same list of questions over and over again, or else it's going to definitely sound rehearsed, and that's just not really useful. Don't waste time on irrelevant details. For every question that you ask somebody in their hearing, you want to have some reason why you're asking it. We recommend a chronological narrative, and that's basically it. The closing statement, should be brief. Again, you want to focus on some of the issues of credibility, any issues raised by the judge or the trial attorney, and kind of put the judge's mind at ease that your client, for various reasons, does fit under the definition of a refugee and should, be granted asylum in the exercise of discretion and all of that. So if you win, you're going to go over with your client some of the next things that they have to do. The main thing is that they can then apply for work authorization. If they win affirmatively, I understand they're now actually just sending the work card to people, so you don't have to worry about that. But they do need to go and apply for a social security number. They're probably going to be all really excited about doing that, so you may already know to do that. And if you lose, you can appeal to the Board of Immigration Appeals. You have to reserve your right to appeal, and then you have to appeal within 30 days. And there's various levels of appeal, which I won't get into, but the Board of Immigration Appeals is the next. It's the Administrative Appeals Board for immigration cases. Thank you very much. Sorry, I was a little rushed at the end.